everyone, and I think good morning to at least Sarah and Sarah. I think it's morning for both of you, but it's good evening for all of us over here. Today's webinar is titled "Understanding the Gaza War Through the Lens of International Law." It's jointly organized by the PUCL and AILAJ. Just a small introduction to that. PUCL is the People's Union of Civil Liberties. It's a human rights organization that was formed way back, established during the emergency of 1975 to 1977 by Mr. Jayaprakash Narayan. And over the past 30 years, PUCL has done commendable work in the areas of human rights and civil liberties across the country. Arvind Narayan is the president of the Karnataka chapter of PUCL. It's PUCL Karnataka. The All India Lawyers Association of Justice, AILAJ, which is the co-organizer here, is an organization of lawyers, legal professionals, and law students striving to protect the core tenets of the Constitution, particularly liberty, equality, justice, and fraternity. Interestingly, just for people to know that when AILAJ was formed a few years ago, one of the first webinar we did was with Michael Spard, the human rights lawyer from Israel, who has been litigating on behalf of Palestinians in the courts of Israel. It was a very enlightening kind of a talk of his, where he spoke in relation to what he called the Israeli occupation and the apartheid state that exists over there. Of course, just for people to know that his book, The Wall and the Gate: Israel, Palestine, and the Legal Battle for Human Rights, is a must-read for any human rights lawyer or civil liberties lawyer who's engaged who's interested in the protection of human rights. Now, coming to to what's happening in Palestine today, definitely I think most of us feel a sense of relief at the temporary ceasefire, which I think, from what reports are coming in now, may have the ceasefire may have ended from all reports. The reuniting of hostages with and prisoners with their families, that was something that really gave us a bit of hope that this kind of a situation that was emerging over there would actually end. Of course, what we'd really like, and which is what across the world people are speaking for, is a lasting ceasefire, and we'll have to wait and see what happens over there. As of now, more than 15,000 people have been killed in Palestine, of whom more than 6,000 are children. More than 1.7 million people have been displaced. The quantum of bombs that have been used in Gaza is unprecedented. Of course, there's much more to the kind of sufferings that the people that are facing over there, which I'm sure our speakers will speak about. I think for us, we are seeing these protests across the world, where people are questioning what's happening in Gaza, demanding for the ceasefire, and this is across the globe. This is in country after country that we are seeing these protests happening. You're also seeing a lot of resistance from within Israel itself, where you have Netanyahu being questioned and his leadership being questioned. You've also had a direct questioning now of their very famous Hannibal Directive itself, and to what role it played in the lives of Israelis being lost in the horrendous attack that happened on October 7th. But I think, for us, I think what we really thought we could do here with our experts is that some of the questions that inevitably rise in this situation. For instance, when does history begin to make sense of the Palestine question? And more often than not, it starts on October 7th. But then, did it start on October 7th? Did it start in 1967 during the Six-Day War? Did it start in 1948 with the first Nakba? Or did it start in 1947 with the UN's partition plan? Did it start in 1917 with the Balfour Declaration? I could go beyond in time, but I think it's an important question that we need to ponder. The second is, of course, how does one legally frame the conditions that are obtaining in Palestine now? Occupation, apartheid, or is this even genocide? I'll just read the small quote from this essay that was written by Rabea Egbaria, who is a human rights attorney completing his doctoral studies at Harvard Law School. Unfortunately, this essay has been the Harvard Law School, the law review has refused to actually publish this. And he writes, "It is much easier to consider genocide in the past tense rather than contend with it in the present. Legal scholars tend to sharpen their pens after the smell of death has dissipated and moral clarity is no longer urgent. So we thought, we'll take that warning from him and let us talk about actually what is happening there. How do we understand it even from an international law perspective? Just two more points before I hand over to Arvind. I think one is some people would argue today that the biggest loss of legitimacy is to the notion of human rights and democracy, and particularly to the notion of international law. That there is this global system of rules that are meant to regulate conduct, even a situation that is obtaining in Palestine. These rules, the so-called system of rules, they even matter today, especially in light of what is happening in Gaza. In short, the question really has a relevance and an application. As far as India is concerned, just to inform our friends, I'm sure you'll know about this. Most Indians are invested in what's happening in Palestine. At the time our country gained independence in 1947, was when you can say to an extent, the UN's partition plan came into effect, and the kind of situation that you see in Palestine kind of begins over there. The government has changed its position in regard to Palestine. We've always, there's been a support for the Palestinian claim for sovereignty. That has been, that's something that every government has followed. But the Indian government not voting for the resolution on ceasefire is a sure marker of a shift. There's another thing that's been happening, which is the clampdown on protests across the country. But despite that, thousands and thousands of people are marching the streets in India as well, asking for justice in Palestine. So I think, these are some of the questions, and this is the context in which we are all gathered here today. I'm really hoping that two of our esteemed speakers will engage in some of these questions, and I'm sure that they will. I'm going to now hand it over to Arvind to introduce Sarah, and really, I really hope that we are able to have a fruitful conversation for the issue. Thank you, Arvind. I think.
Thanks, Clifton, for providing a general framework and an introduction to the concerns which we have before us. And just to give a quick introduction to both our speakers, and to say that we're really very, very pleased to have both of them here. Sarah Lee, and both of them are called Sarah. So Sarah Lee Whitson, who is going to be our first speaker, is was the director of the MENA, the Middle East and North Africa division of the Human Rights Watch from 2004 to 2020. And she's now the executive director of Democracy for an Arab World Now, DAWN. And again, if you just do a little bit of a search for Sarah Lee online, you'll find a really remarkable body of work on literally the question of democracy in the Arab world, be it Iran, be it Saudi Arabia, be it the occupied Palestinian territories. You'll find her statements and her work or advocacy around issues of democracy in the Middle East. So we're very, very pleased to have Sarah Lee with us here today. And Clifton has already posed a range of questions, which I'm sure you can start from. And the specific point for us also is, as Clifton indicated, how do we understand, in a sense, the relevance or the importance of international humanitarian law, international human rights law, international criminal law, as far as this particular conflict is concerned? I think all of us have been watching the horrific, really, images of the bombing which has been carried on in Gaza, and everybody's trying to find out what is the language in which one responds to this grave kind of a violation. And since, of course, you had extensive experience with the human rights world, being both a lawyer and as obviously a very strong advocate on the question of the rights of the people of the Middle East and North Africa, it'll be really, really wonderful to hear from you, Sarah Lee. So without further ado, I hand over the floor to you.
Thank you for that, Arvind, and thank you to all of the human rights and civil liberties lawyers in India. I'm really honored to be speaking with you and addressing you, and it's heartening to see such a strong turnout, and really it's heartening to see so many of you focused on the situation in Palestine when you were also at the same time dealing with such a massive crisis of human rights and civil liberties in India. So thank you for extending yourselves beyond the borders of India to focus on the unbelievable destruction of life that we have been seeing in Gaza for over 6 weeks now, and the resumption of hostilities today. I want to just give an overview of the international laws that apply in the situation of the conflict right now underway. Maybe address some of the hot issues that are bandied about as accusations. And then talk about sort of the remedies that are available and the political context that frustrates the availability of those remedies, which I think can rightly lead all of us to question whether international law still has any relevance, whether international humanitarian law has sufficient universal applicability to truly be called international, or whether it's just a political cudgel that's used selectively and enforced even more selectively for and by powerful states to pursue their own interests. I'm delighted to hear that you had Michael Sfard on as a speaker previously. Michael is a very dear friend of mine for many, many years, and is actually a non-resident fellow at Dawn who has written for us extensively, and he's truly one of my heroes. Just an amazing, amazing individual and lovely, lovely human being. So feel free to interrupt me if what I'm saying is either going on too long or too basic or too much in the weeds, because I really don't know the extent to which the people on the phone are immersed or not immersed in international humanitarian law. International humanitarian law and human rights law are the principal laws applicable anytime there's an armed conflict. And it's important to emphasize that human rights law doesn't just disappear, but if can fairly be said, really takes a subordinate status to the specific rules that govern in times of armed conflict. And the very most basic principle of the Geneva Conventions and the treaties of international humanitarian law that precede the Geneva Conventions is the concept of sparing civilians from attack and restraining armed parties to a conflict from targeting or indiscriminately attacking civilians. So basically, the laws of war say in a time of armed conflict, you can only target people actively participating in hostilities, which are typically uniformed soldiers, but are sometimes combatants who are not uniformed, but are otherwise actively participating in hostilities. And you can't target civilians, nor can you indiscriminately attack an object or a place if you're unable to distinguish between the civilian and military targets there. Where you do have a military target in mind and civilians are present, in no circumstances may the attack be disproportionate. And I think that proportionality criteria is the one that is most often abused and most subjective, because different states have different criteria for what is proportionate. So if you are going to hit, let's say, the Minister of Defense in Israel as a legitimate military target in command and control of all the military operations, how many civilians can you justifiably take down with him as a proportionate attack? And some militaries have a ratio of 10-1 or 50-1, but I don't think that we've seen any sort of realm of normal proportionality where they claim to be targeting a military object. I think it's important to emphasize that both Hamas as an armed group and the Israeli Defense Forces are subject to international humanitarian law, while Israel as a state is subject to the full panoply of the Geneva Conventions. Hamas as an armed group is really just subject to Common Article 3, which requires distinction between civilians and militants or active combatants, and restrictions on murder, treatment, cruel treatment, and torture of anybody. Now, obviously, Hamas has violated this fundamental precept of international law in its heinous attack on civilians in Israel on October 7. The estimates of those killed in that attack are really still being reviewed, still being revealed. I think the numbers have now been reduced to 1,200 killed in that attack. I think that the estimates of military targets have ranged between 300 to 400 to 500, we don't know. And of the, let's say, 800 civilians who were likely killed in the Hamas attack, there is some now ongoing dispute about how many of those were killed by Hamas versus those killed by Israeli friendly fire in their counterattack on the Hamas offensive. Unfortunately, it's become a political football, and even talking about Israelis who may have been killed by is basically forbidden, because if anyone dares to discuss these issues as a matter of fact, they're seen as being Hamas sympathizers and Hamas defenders and so forth. And I think that is one of the issues in a broad way that makes it so difficult to talk about the facts about this armed conflict, because when you question or challenge Israel Defense Forces, you're seen as sympathizing or defending Hamas, which is, unfortunate for human rights practitioners, for human rights lawyers, whose focus, of course, is on the facts and the law. So you may recall, for example, the very widespread allegations repeated by media around the world that there were dozens of babies decapitated by Hamas. Those of us who questioned that narrative or demanded to see evidence of it were dismissed and attacked as Hamas sympathizers and apologists. But we now know that there's actually zero evidence of Hamas decapitating any babies. And that is just an unfortunate context. And for those of us who wade into the territory of conflict between Israel and the Palestinian people, have to contend with these kinds of personal attacks against us, basically to silence us. A couple of things on the framework of international humanitarian law, and that is the distinction between the decision to go to war, and that is that's got some fancy Latin words for it, but it's the ad bello rules of law versus the in bello rules of law, which basically distinguishes between the legitimacy of a decision to go to war, who can take up arms, when they can take up arms, and then concepts of self-defense come in. So is Hamas entitled to fight to resist the occupation? I think you'll find plenty of international legal commentary that says yes, people have a right to resist occupation. People have a right to defend themselves from a brutal military occupation that has subjected them to a blockade and a siege since 2006. Just as the questions of whether or not Israel has a so-called right to defend itself from attack, the right and the obligation and the duty to protect its own citizens, excuse me, and subjects from attack. I think that is an issue that is of less relevance to where international humanitarian law practitioners tend to spend their time, which is about how a conflict is fought, how parties they're fighting. And that is where you will find human rights organizations like Human Rights Watch or Amnesty International overwhelmingly dedicating and devoting their time. Now, I'll put that as a footnote that there is now sort of an open debate of the unwillingness of organizations like Human Rights Watch to address the decision to go to an armed conflict and the call for a ceasefire. Because, for example, Human Rights Watch says that they don't engage on that issue of why parties go to war and whether they should be allowed to go to war. My organization does. We were the first major organization to call for a ceasefire in Gaza. We made that call on October 9, the very first day that the fighting started. Amnesty International did follow us, and we're very happy about that. But Human Rights Watch has still not called for a ceasefire, which has now become a subject of fighting and debate within the sort of human rights community. But I think what's important to emphasize is that a party to a conflict need not be a state to take up arms or to lawfully take up arms, and has a right as an armed group to fight. And of course, governments around the world support armed groups when they want to, when they feel like it, when they believe it's in their interests, without worrying about whether or not that armed group has a right to take up arms. And the recent war in Syria, the sadly ongoing war in Syria, is an example of that, where the United States was actively arming, as was Turkey, as was some Arab Gulf states, armed groups in Syria to fight against the tyranny and abuse of the Syrian government. No one questioned the right of Syrian armed groups to resist the atrocious repression that they live under. And similarly, Iran is now supporting various armed groups who are also fighting against tyranny, occupation, abuses, and so forth. I think the more important question for us is to examine how this war is being fought. And as I emphasized initially, the key issue here is a distinction between civilian and combatant. And where I think it's important to emphasize, and where this gets confused, is that in looking at the war in Gaza, I would fairly conclude, as we have seen in prior wars, is that Israel refuses to recognize the distinction between civilian and combatants, and has done so for a very long time. Instead of respecting the laws that require distinguishing between civilians and combatants, Israel has come up with its own category, one that is recognized by no one other than those in its own little window in their own heads, which is a category of terrorism and terrorist. So Israel, if you'll note in its statements, says we are targeting the Hamas terrorists, the Hamas terrorist infrastructure, and everyone associated with Hamas. As in prior wars, as in the war in Lebanon with regards to Hezbollah, Israel has decided its own category of terrorist, which is not something that is actually recognized in international humanitarian law. There's no such category of terrorist in who can be subject to attack. But instead, Israel targets not only combatants, but, for example, the civilian infrastructure of Hamas as the civilian government governing in Gaza. And that is why it has targeted, for example, the Ministry of Justice, which is a civilian body carrying out civilian functions, or in prior years, the traffic police or the police cadets, who were operating basically as civilian police and not part of the fighting. Why it has targeted dozens of journalists, alleging that they are, quote unquote, supporters of Hamas. And so by broadening the definition of a target to include anyone who, quote unquote, supports Hamas or is a supporter of Hamas or a member of Hamas, Israel collapses the distinction that requires parties to a conflict to target only military and military objects. But before we get to that, I think we can best illustrate some of the principles of international law by focusing on how this conflict has been fought. First and foremost, Israel announced a total blockade on the Gaza Strip, blocking the transmission, the import of fuel, water, medicine, and electricity. All of the items that are essential to the survival of civilian population. And because Gaza is under occupation and because its borders are controlled by Israel, supported by Egypt. This total blockade is really exhibit one of a clear-cut black letter war crime. So the laws of war are very clear that you cannot deprive civilians of items essential to their survival. A blockade on water and fuel and electricity and food is obviously first and foremost going to harm civilians and effectively, collectively punish them for the crimes of Hamas or in Israel's war against Hamas. So if Israel did nothing more, it didn't drop a single bomb and only enforce this blockade, it would be already committing a very, very serious war crime. And that's why, though we are seeing a death toll of 15,000, more likely 20,000, approximately at least 80% of whom are civilians by the Israel Defense Force's own estimates of having killed 1,000 to 2,000 Hamas fighters in the past 6 weeks, the majority of whom, as was noted, are women and children. And we expect that death toll to rise dramatically because of the waterborne diseases, because of the lack of access to electricity, fuel, and medicine that will make disease spread in Gaza and primarily impact the very young and the very old, as waterborne diseases tend to do. In addition, of course, we have seen the actual bombardment. And here again, some of the political footballs come into play. So Gaza is a densely populated area, perhaps one of the most densely populated areas in the world. It is a tiny, tiny territory where the 2.3 million people in Gaza have been crammed in, unable to leave the vast majority, with very little exception, since 2006, living primarily in apartment buildings that contain generations of families in a very traditional, probably not uncommon in India, where a family will have one son take one floor, another daughter and her husband take another floor, their children living in various floors of an apartment or various apartments in a building. And that's why when you read about a person having lost 10, 20, 30, 40, even 50 family members in one bombardment, it is because in taking out an apartment building, you are taking out generations of family members. And in targeting or allegedly targeting a Hamas fighter who may be living in one of those apartment buildings, you are killing hundreds of people, hundreds of family members who may be living in that apartment building. Now, what we know about Israel's bombardment, what we know about the thousands and thousands and thousands of bombs that Israel has deployed, is that many of them are bombs of 1,000, 2,000, 3,000 pound capacity with very wide area effects. Israel has been using 155 millimeter artillery shells, which have very wide area effects and are by their own nature inherently indiscriminate. When they are deployed, you cannot contain the bombardment to the item that you're targeting, but rather a very wide area radius is damaged. So therefore, they cannot be targeted with any actual precision. In addition, because of the dense population of Gaza, because of the fact that militants, fighters are present in civilian areas, because almost all of Gaza is intermixed civilian areas, it is really quite impossible to carry out a military attack in Gaza that targets only a military object. That is the challenge of fighting in an urban context. Just as if Russia targets a city in Ukraine, where they will find Ukrainian military forces present defending their cities, so too in urban civilian areas in Gaza, you will find Gaza militants, fighters, either present there to defend their cities from attack, or present there because there's no other place to fight from. Now, what you will find very typically are the accusations of human shielding, that the reason why we're seeing such a high death toll in Gaza is because Hamas is hiding behind civilian areas, using civilians to shield themselves from attack. But that allegation is one that has actually quite a high bar of proof. In order to prove the crime of human shielding, you have to show that the military force is actively, deliberately using a civilian in order to shield itself from attack. So we have documented many, many cases of this kind of civilian shielding. But I must say that they have been conducted by Israeli forces who have, for example, used civilians, children even, to knock on doors of militants to gain entry before attempting to attack a home where fighters may be present, who have used civilians as they carry out, but that needs to be distinguished in areas. Here, international law says that parties to a conflict have an obligation to avoid endangering civilians by placing their forces to the extent feasible. And those 4 words, to the extent feasible, are critical for a legal analysis because they recognizes that it's not always feasible to put your military forces and your weapons in an area where there are no civilians. Urban warfare is a reality. If it's feasible to avoid protecting civilians, you should and you must. But in certain circumstances, it's not feasible for the reasons that I described. Densely populated areas, no wide open areas where you can base your military forces feasibly without, of course, destroying your military strategy and so forth. So while Hamas may be guilty of failing to avoid endangering civilians by putting its forces in civilian areas, that is a question of feasibility that needs to be examined. But in no circumstances does Hamas's failure to avoid endangering civilians mean that the civilians in that area are therefore free targets, open game. And that is what Israel has done. Israel has treated the entire area of northern Gaza as an open fire zone, making no distinguishing between civilian and military targets. And the rubble that you see in northern Gaza is really the best evidence of that. The death toll that you see of overwhelmingly civilian casualties. I don't think I have seen such a ratio of 1,000 to 2,000 fighters killed out of 15 to 20,000 civilians killed in any conflict that I've ever worked on before. So it is, sort of prima facie evidence of a deliberate disregard of the laws of war. I want to emphasize one final point before I move on to the remedies. And if I'm speaking too long, I'm happy to pause, so feel free to interrupt me. And that is the deliberate targeting of civilians. This is a much higher offense, but I think it's one where we have seen Hamas conduct in its deliberate attack on this concert, the deliberate killing of civilians, killing in a kibbutz, the deliberate hostage taking of civilians. But as well, for example, when Israel deliberately targets journalists, and there have been over 50 journalists targeted deliberately and killed in Gaza, that is a higher level crime because it is killing a civilian deliberately despite their status as a civilian, as opposed to an indiscriminate attack that fails to distinguish between a military and civilian object. Just moving on to some of the remedies, and there's a lot more that can be said. Well, actually, let me just touch on 2 other crimes that you addressed. One is the crime of forced displacement of a civilian population, also commonly popularly referred to as ethnic cleansing, is something that we have seen in Gaza with over 1.7 million Palestinians forcibly displaced by Israel to southern Gaza. We have seen Israeli government statements that make it clear that their intent is to forcibly displace the Palestinians. My estimation is that they will at minimum seek to create a buffer zone in northern Gaza and never allow civilians to return there. We have seen excuse me, Israeli intelligence ministry plans saying that their actual intent is to displace all of Gaza's civilians, all of Gaza's populations to Sinai. We have seen US government funding include funding to house and build infrastructure for the housing of Gaza's populations in the Sinai. This is something that the Egyptian government is resisting. But all of these factors add up to the crime of forced displacement, an actual intent to push out the population of Gaza, actually a long-held plan of Prime Minister Netanyahu and Israeli military going back many decades that we're now seeing in place. On the question of genocide, my organization has not yet made a determination of genocide, but I should note that over 50 genocide scholars of numerous organizations have put out a number of findings that the crime of genocide as defined in the Genocide Convention, including both incitement to genocide and the deliberate destruction in whole or in part of a population based on their national origin, is underway. We are organizing a major conference on Monday in New York City, the same week when the International Criminal Court is presenting its annual report to the Security Council in New York about investigating those academics, scholars, experts, practitioners who've made the charge of genocide, to analyze and really question that charge before we come out with our determination. But it is something that I think all human rights practitioners, for the reasons highlighted in the article that was rejected by Harvard Law School's Harvard Law Review, should be grappling with and addressing now, while it's underway. But I will remind everyone that the US government made a finding of genocide in Myanmar based on the forced displacement of the population, of the Rohingya population from Myanmar to Bangladesh, without even reaching the finding of the widespread killings in whole or in part and so forth. So a genocide determination has been made by the US government purely on the basis of the facts of the forced displacement that we've seen in Myanmar. So I think everyone should keep that in mind in terms of the criteria. There is an ongoing investigation at the International Criminal Court that has formally been launched since 2019 in Palestine. We have tried to push, we have tried to push the International Criminal Court to do its job, for the prosecutor, Mr. Khan, to do his job, as opposed to the foot dragging that we've seen for the past 4 years of doing absolutely nothing on the question of war crimes in Palestine since 2014. The mandate of the International Criminal Court goes back to 2014, and I think it's important to emphasize that Israeli forces, that Israeli officials are subject to the jurisdiction of the International Criminal Court in this ongoing investigation, notwithstanding the fact that Israel is not a party to the International Criminal Court's Rome Statute. That doesn't matter. Once the ICC has jurisdiction, as the International Criminal Court has confirmed that it does, in Palestine, in the occupied Palestinian territories, anyone who commits a war crime there or a violation of the Rome Statute is subject to the jurisdiction of the court. I believe that it will be the ultimate test of the credibility of the criminal court and its survival as an institution, whether or not it proceeds to robustly investigate Israeli abuses in this conflict, which of course includes the war crime of settlements in the West Bank and East Jerusalem, but also this current conflict. And what I have argued is that if the International Criminal Court fails to aggressively prosecute this matter, it will be the death of the International Criminal Court, and you will see member states, particularly those in Africa, who have already threatened to withdraw. Some have already withdrawn, accusing the court of being a biased, partisan, politicized court, noting here that before the war had actually fully started in Ukraine, the International Criminal Court and the prosecutor deployed 43 investigators to Ukraine, allocated a massive budget to Ukraine, has already issued an indictment against Putin and other Russian officials for the forcible transfer of Ukrainian children to Russia. But now, over 4 years into the crimes in Palestine, has not appointed a single investigator. And I think that is pretty shocking. What I don't want to take up all the time for, and what I'd like us to reserve maybe in the other discussion, is the way in which this conflict is transmitting abuses and repression globally. And the most important way we're seeing this happen is in violations of the right to speech and the right to protest. So basically, while we are seeing unprecedented vocal popular support for Palestinian rights, for Palestinian freedom, for an end to occupation and an end to apartheid, and most importantly right now, a ceasefire, we have seen governments around the world basically exporting Israel's repression to their own populations, issuing restrictions on speech and expression and protest that we have never seen before. And what I have argued before, and I think we are sadly seeing quite a bit in the United States, perhaps not to the levels of Germany, is the willingness of the American government to quelch the First Amendment in the United States, to quelch the freedoms of its own citizens, to silence and sanction and punish American citizens in order to shield Israel from attack. We have seen Western states willing to abandon international law, destroy the International Criminal Court, if it means protecting Israel from criticism. And I think that it is very important for us to resist not only the destruction, the unlawful destruction of Palestinian life in Gaza, but also this unbelievable spread of repression in our own countries for the sole and exclusive purpose of shielding Israel from global criticism, scrutiny, and accountability. I'm going to pause there. I hope I haven't gone on too long. It's really just too much to say, but I'll pause there.
No, thank you. Thank you so much, Sarah Lee. That was really very, very instructive as far as all of us were concerned. And you taking us through the entire framework of, the idea of international humanitarian law. And my understanding of what you were saying is there's a certain way in which you're saying the principles, which is the principle of distinction and the principle of proportionality, and how they've been violated in such an unbelievable way by Israel, as well as taking us through the potential of using international criminal law as far as addressing some of the violations of this conflict. And thirdly, of course, the wonderful, the important point you made of how this, you're talking about the repression, the export of Israel's repression to all parts of the world. And again, that's something we know very intimately in India. And so thank you again for raising that very important point. We'll come back in terms of the discussion and give you some time, I think, to recover a little bit. And we go down to Sarah Khan, who is, Sarah, are you there?
I'm here.
Yeah, wonderful, wonderful. Who is the research scholar at the Osgoode Law School, and who's had an extensive experience working in the humanitarian law sector as an international civil servant with the United Nations for a number of years. And Sarah Khan in particular was very keen on addressing the entire question of the protection of civilians framework and looking at international law from that international humanitarian law from that particular lens. Without further ado, Sarah, the floor is yours.
Okay, thank you so much. I just might add a couple of things to what Sarah Lee was saying. It was very instructive. Thanks a lot, Sarah. Just to say, I mean, with IHL, really, I think we have to be very clear that IHL allows violence. It's not a law which prohibits the use of force. It's about minimizing the impact on people who are not taking part in the hostilities, but it is very much, it accepts war. So when we talk about principles of proportionality and distinction, we also have another principle of military necessity. So that comes in as well. And that's something that all belligerents really do focus on. They say, well, yeah, this was necessary. And then you start looking at the distinction and proportionality. I just want to make another point that's around the notion of collateral damage. So Sarah was talking about how densely populated Gaza is. In the last decade, there's been a lot of focus on urban conflict. You've had conflicts in Syria, you had Aleppo, you had Raqqa, then you had conflicts in Iraq, Mosul, Fallujah. They're all in densely urban areas. A lot of the weaponry that's been manufactured over the years is actually not suited for these conflicts. There are some very precise weapons. I mean, Sarah's probably seen these. I've seen them in Afghanistan, where they can take out precisely some things, but not in such densely populated areas. So the notion of collateral damage comes up very often when militaries are sort of justifying their actions, and they say, well, we did not aim this at civilians, but we are, a few civilians have died. And that's something that IHL accepts. It's not like IHL says that is not acceptable. The issue is proportionality, and I know Sarah's already explained that, so I won't really go into that. The problem with the notion of collateral damage is it's still focused very much on right to life. It's really focused on civilian casualties. There's a lot of discussion around that. Increasingly, there's a lot of discussion around damage to infrastructure. So, you know, you get notions of health infrastructure being destroyed and so on. Displacement is very hard to be seen as a crime. You do have displacement being recognized, especially when people cross borders. So what Sarah was talking about with Myanmar, international tribunals tend to uphold that. When it comes to displacement within an area where you're not crossing borders, it's extremely hard. However, with Gaza, it's extremely clear. There is forced displacement. If you're evacuating people, which is allowed, a military power can evacuate people, that is, request them to move out from a fighting area. Here, it really has been the case that you have not had evacuation routes, which have been set up properly. People have not been advised where to go. They have not gone to places which can support them. You've had earlier conflicts. So you had places like Mosul, where similarly you had a densely packed area. But one of the things that was set up, although they didn't work perfectly, nothing ever works perfectly in the fog of war, is evacuation corridors. The idea was civilians could leave. With Gaza, that has just not been an option. There hasn't been any preparation in the places that they have fled to in southern Gaza, let alone leave Gaza. I know there are political connotations around why people shouldn't be moving out of Gaza. So displacement's a very hard one. I've worked for years on displacement, so I'm delighted to see that there is a focus on this crime, because usually forced displacement really isn't focused on at all in a lot of conflicts. The other thing I really just wanted to comment on was on classification of the conflict. It's always a very tricky one. Countries who are taking part in a conflict will define it in a certain way. You have actors like the International Red Cross who will define it in a certain way. Sometimes the two meet, not in other cases. I would say really look at the classification of the conflict by going to Human Rights Watch, going to Dawn, going to ICRC especially, who do try, especially ICRC, to give a more neutral sense of what the classification of this current conflict is. Then just on the issue of conduct, reasons for going to war, as well as conduct of hostilities, international humanitarian law really is focused on conduct of hostilities. You have two kinds of areas which are examined. One is Hague law and one is the Geneva law. So Hague law is about regulating uses of weapons that are being applied in the conflict. And then you have the Geneva laws, which is about all the people who are not taking part in conflict. Everyone is assumed to be a civilian unless proven otherwise. That's a very important point to keep in mind. Your de facto assumption is they are civilians, and you're supposed to be taking as many measures as possible to minimize harm to civilians. I just want to make a point on the destruction of property in Gaza. This is not a crime as yet, but it's a notion that in the last few years is being discussed extensively, again, based on the kind of horrific damage that's happened in places like Syria and Iraq, which is the notion of domicide, which basically means you destroy infrastructure and housing so badly that even if people eventually want to go back to their homes, there's nothing for them to live in. You've completely destroyed their environment. Hopefully in the future, we're going to see this crime really becoming a crime, but it's the crime of domicide. Now, ethnic cleansing, I would not necessarily equate it to forced displacement. It's not a crime in international law, but it's a very powerful term to use to describe an intent that's occurring. So you're trying to move people out. If there is ethnic cleansing being undertaken, you can easily apply it as being a crime of genocide, or you can apply it as being a crime against humanity. All these are crimes which are covered in international law. So I would not, I keep hearing this on Twitter and things like that saying, oh, ethnic cleansing is not a crime, but actually it's a very powerful word. And it's a word that really describes a certain intent. Then I think the last thing I would really say around this is, sorry, I was writing notes as Sarah was speaking, which was really interesting. Yeah, international law. I actually believe in the value of international law, however much it is being criticized right now. The thing is, I think let's be very clear, and I think especially for domestic lawyers, international law is slightly not law in the sense we don't have a police, we don't have an entire system around it. You do have the International Criminal Court, but as Sarah was also saying, there are lots of issues about which situations they will investigate, which situations they will not investigate. They are underfunded and so on. They can't come and arrest a perpetrator. So international law is very fluid. What is powerful about international law is it gives you standards to argue against. It enables you to have the tools to call out the hypocrisy of different actors. International law is very often used by states also to justify their actions. I don't think they are necessarily saying we're not following international law, but they pick and choose which laws they are following or how they interpret the law. So it's a constant dialogue and contestation around international law. International law is politics. I mean, it's not just applying the law and saying this is the crime and let us have it, you can go to jail. International law very much is the reflection of a political moment. Now, I'll just talk about the last thing on this situation is UNRWA, that's the UN Relief Agency. It's interesting. Normally, actors like ICRC or the UN Refugee Agency have a very strong, what we call a protection mandate. What that means is they look at certain treaties and conventions and they call out violations on those conventions. UNRWA deliberately was not given a protection mandate when it was set up. It was set up to be purely a relief actor. I think it's remarkable what it's been doing through this crisis, actually. They've really been monitoring and calling out violations, which is the core of protection of civilians work. I think this conflict in Israel pretty much, and I would love to hear Sarah's point on this one, is it is a continuation of the post 9/11 wars. you do have the same kind of things being applied. This notion of self-defense, saying that we have the right to defend ourselves, is getting stretched immensely. It's the same thing that happened with Iraq, saying we're going in because it's about our security, and Saddam is a threat, or even Afghanistan. That has led to a continued sense of violence in a lot of places around the world. Even though you see in places like Afghanistan, these wars are supposed to be winding down, the violations continue. So I think that's something we really have to keep in mind, that in the last 20 years, there's been an incredible permissiveness of violence that is being allowed in the name of saying, well, we're trying to regulate the violence through international humanitarian law. Now I'll just come to my topic, which I wanted to focus on, but I just wanted to reflect on a couple of these things as well. So I just want to talk about protection of civilians measures, basically. And I think this might be of interest to a lot of people if you're working around situations of violence. But protection of civilian measures is really applying a bundle of rights in a situation of violence. So you're applying not just IHL, you're applying human rights, you're applying refugee law. Protection of civilians originally came out from IHL. It was about protecting civilians in conflict, but now it's become a much broader term, which encompasses a lot of different things. So people use protection of civilians as a way to react to the violence that's going on right now. It's not just about documenting the harm or collecting the information for an eventual prosecution of at the International Criminal Court, but it really is about how do we minimize the harm that's occurring right now. So what does that mean? You're looking at things like, are people getting access to services? Are they able to get food? In Gaza, what we're seeing now is starvation potentially is being used as a weapon of war. So when it comes to protection of civilian measures, you're really advocating to get humanitarian assistance in. Protection of civilian measures also include things like looking at infrastructure. So this notion of domicide is really emerging from protection of civilians work. It's not necessarily entirely covered with an IHL, so you have to fall back on human rights law for that as well. Humanitarian evacuations, the idea of how you conduct evacuations is a protection of civilians notions. Weapons, you have in the last year, 80 countries have signed on to a declaration which regulates the use of explosive weapons. What you mean by explosive weapons is it's not banned weapons, but it's weapons which, somebody explained this to me, but it's, if a weapon falls, the impact is so huge. It's a big burst. That burst can damage a lot of things. In densely populated areas, that harm can be incredible. The US has also signed on to this declaration. Others have also signed on to this declaration. The idea is to minimize using these kinds of explosive weapons in conflict zones. You also have another declaration, which is on protecting schools. I just want to talk about the notion of reverberating effects. Okay, this is something that's again emerging in the last decade. It's still a slightly contested notion, but the idea is the harm in conflict has 2-3 degrees. So even if a military actor says, no, we have ensured distinction, this is a military necessity that we strike this place, the issue is what happens later. So let me give you an example. You have a school and you have perhaps a camp of fighters next to the school. If the fighters are being attacked, what happens as a secondary effect or third effect is, apart from the damage to the school, it's very unlikely that kids will ever return to that school. Parents are not going to send their kids to a place which is located next to a target. So this is what we call about second or third degrees of harm. It's still very contested because a lot of militaries don't recognize it. In IHL, it's a very limited notion, but even now the ICRC is beginning to acknowledge the reverberating effects are extremely important and extremely extensive in conflict. You have people who get displaced, for example. They can't really come back ever. That's again a reverberating effect, because what has happened, for example, in a place like Mosul, not even Mosul, Fallujah, everyone keeps talking about Fallujah on Twitter in Iraq. That's like a decade ago. But even now, people are struggling to return. People are struggling to resume their lives. So these are all the second and third degree impacts from conflict which come out. So I think one of the things actors have done is talking about ceasefire. I think there isn't enough attention on trying to end conflict anymore. I would recommend, if people have not read it, a book by somebody called Samuel Moen, Humane. I don't agree with all parts of that book, but he has a very good point there, which is there has been, since September 11th, 2001, there has been a window dressing around IHL and other laws saying we are following them. Governments feel good by saying that and mouthing it, but in reality, the harm has been extensive. And what has fallen off the shelf of international law is things like the law of aggression. Yes, it briefly came back because of Russia, but nobody is really talking about ending conflicts and making peace anymore. It really is just about how do we minimize the violence. We accept the violence, but we just want to minimize it. So I would really recommend that as well. Okay, I think those are the only points from me, but thank you very much.
Thanks, Sarah. That was really very instructive. And the idea of the critique of international humanitarian law and how necessity interacts with the other two principles is something you brought up. The idea of, I think, domicide as a point of destruction, so the people can never return to that area. Again, that's a very important notion which you brought up. The idea of self-defense and how the idea of self-defense is being stressed again is an important principle which you raised. I think the range of, within both Sarah Lee and Sarah Khan, range of really very important concepts have been raised, which have been very educative as far as all of us are concerned. I'm sure the people who stayed here for so long come from around the country, and I'm sure maybe many parts of the world as well, have many questions to both our speakers. So I'll encourage you to please put your questions in the chat, and we can place it before both the speakers. I think we have one question, maybe to...
Sorry, Arvind, before you jump in the question, can I just interrupt with one last point, which I forgot? I just want to say one thing. I think we are looking at Palestine. There is a history of harm and so on, but there has also been harm in Israel. I think we should not negate that. There isn't a hierarchy of harms or hurt. In a conflict, civilians on both sides get hurt very often, but indeed, I don't want to go into the specifics of the situation of Gaza, Israel, because Sarah is more the expert on it, but I just want to say that we have to recognize harm for civilians all around. That is very important. Thanks. Sorry, thank you.
No worries. Two questions I have. Maybe both speakers can look at these two questions. Or three questions, okay. I'm going to put all three questions together, so maybe you can just take it as a bunch. That'll be, rather than taking question by question. Comment question number one. Doubtlessly, Israel is a terrorist country and Netanyahu is a war criminal, but could he be tried in the ICJ? Second part of it, can any action be taken against this war criminal? Second comment. Thank you so much to learn here. Both speakers were excellent, very interesting concepts. Some suggested readings would be very good. The other question, second question, what would be the role of India in this war? Should India support Israel by stating that Israel is just protecting its sovereignty, or should it take the side of humanity and support the people of Gaza by voting against Israel in international law committees? Should we stop with this and do you want to address it, or shall I just read the two other points?
I think we can stop with this. There's that other question, we can take that next, the one on
Sure.
manufacturing.
Yeah, sure. So, Sarali, would you like to?
Yeah, I mean, I'm not sure I fully understood the questions, but let me try to address what I think the last question is getting at. Should India support Israeli sovereignty or the people of Gaza? You know, I hope that all of us can first and foremost be on one team, and that's Team Civilian. And I'm not interested in national contests or ethnic contests or religious contests. I'm quite skeptical of all of those categories and labels. The contests I believe in, the contests where I want to take a side, are the side of human rights, universal human rights, the side of international law, international humanitarian law that protects civilians, the side that rejects military occupation, particularly a permanent military occupation, the side that rejects apartheid, the side that rejects genocide. So I would suggest that we consider ourselves being on the side that will maximize the protection of human beings everywhere, whether they're Israeli or Palestinian. And that's what the laws of war are designed to do. If we don't allow for the protection of civilians in Gaza, we can be assured that Russia will care little about the protection of civilians in Ukraine. Or, you know, I can cite one of a dozen other conflicts underway where we desperately want a party to a conflict to respect civilians. But it's really an all or nothing proposition, because once the United States, the globe's leading superpower, still the leading superpower, clinging by hair, supports the abandonment of international laws designed to protect civilians, international accountability designed to enforce the protection of civilians, then we can rest assured that no other government in the world will respect the laws of war, because why should they? You know, when you think about where Putin is standing now, being indicted by the International Criminal Court, while it sees that the US government is doing everything it can to block any ICC accountability for Israel, that's hardly going to persuade Putin or anybody else that this is a serious, legitimate undertaking. It is to everyone's disadvantage to allow any government to get away with war crimes and crimes against humanity that we're seeing now in Gaza. So if you care nothing about Palestinians or Israelis, you should care about the laws and upholding the laws of war, because that is all we have to separate us and protect us from the laws of the jungle. If we want to say that our societies, our countries, our world have evolved from a place where we would never tolerate the dropping of an atomic bomb on civilians, as we saw in Japan by the United States, if we are now saying we will never again permit a genocide or a Holocaust like we saw against the Armenians, the Armenian genocide, or the Jews in the Holocaust, then we must act to enforce these laws regardless of who is carrying them out. And, you know, the message that my organization keeps sending to the Biden administration is that what's at stake is not just Israel's particular victory in a particular battle that you seem desperate to secure and defend for, sadly, some very undemocratic reasons here in the United States. You are sacrificing not just the Palestinian people, but the global credibility of the United States as a legitimate actor, the global credibility of the laws of war. You are endangering American forces, American civilians. If Israel can bombard places of worship in Gaza, churches, mosques, schools, then why should the next armed group who decides to attack America exempt schools and churches? No one is immune from attack in 2023. If October 7 has taught us anything, is that we cannot underestimate the grievances of people. Even the most weak and defenseless people will fight a way to push back. And if we want everybody to respect civilians, then we have to enforce the respect for civilians, including by our so-called partners and allies.
Thank you, Sarah. Sarah, go on.
I think Sarah's covered all the points. It's excellent. I think the only thing I will say is, and this is where you have the protection of civilians lens, is you are looking at harm on both sides. You're applying not just the law, but you're applying morality, you're applying notions of humanity. I mean, Arvind, I think I shared with you in Clifton, but I wrote the same thing for the Canadian government, saying basically how Canada also needs to sort of use this lens and recognize the harm on both sides for civilians. And that's going to add to credibility, because what's happened through this crisis really is there's been a staunch support of one side rather than both sides of this conflict. As the civilians' deaths have increased, for example, in Palestine, there's been a shift of mood in political capitals. There's suddenly a focus on saying, minimize the harm, minimize the harm. But perhaps there really should have been at the beginning a consideration of, have we put civilians at the center of this? I just want to add a completely different point, but which might be useful for everyone is, and the international community really is stuck with the tools from about 20 years ago. But you did have, at least with the UN, concepts of responsibility to protect. You have notions of human security. The idea was really, when you have such huge harms, the international community should be intervening to avert and prevent them. Unfortunately, they haven't quite worked out that way. There hasn't been much prevention, but these are tools which are worth revisiting. Protection of civilians is the only notion which has expanded exponentially in the last 20 years. Different topics have come under it only because various belligerent parties, including the US, really focused on protection of civilians. So again, that's there in the Moen book, but that's all I can say on this point. Thanks. Yeah.
Thank you. Thank you. We have a range of other comments, and maybe I won't read all of them in the interest of time, but the broad point which people are making, maybe I'll just read out one comment, which gives you the broad sense of the room, as it were. Without taking away the human rights activists' effort in educating people about international law and creating empathy for the oppressed, my question is whether any law exists, especially post-91 or say after 9/11. If the answer is no, then what can be done in future to ensure the integrity of the laws? Is the UN doing anything about it? So the broad question is, in terms of we've understood in a sense, I think from both Saras, that the way we see international law is providing a normative framework or a normative lens with which you approach the conflict. We're not approaching it purely from the point of view of power alone. We are able to say that this is a violation of a principle of proportionality or principle of distinction. And this is in a sense very, very important, because again, going back to our national experience, a very important human rights activist in India called rights as part of the moral storehouse of mankind. So in a sense, it's a way we come from, it's a space we come from, say this is the normative frame we use to look at whether this is right or this is wrong. So that point, I think, I've got from both of your presentations. But the question still remains, in an institutional sense, in terms of the United Nations, are there any proposals or solutions you have in how do we ensure that this normative framework becomes actualized at the ground level? Is there any proposal for reform or change which you have to ensure that the international human rights law, international humanitarian law becomes something which can be actualized? Again, Sarah Lee, yeah.
Yeah, sure. I mean, I think that the most important reform proposals have to do with reforming the UN Security Council and ending the tyranny of the five. Unfortunately, the UN Security Council is the only body that is, let's say, best able to enforce international law, that is able to deploy military force, troops, peacekeeping troops, to uphold international law, to sanction governments that violate international law. But what we've seen is that each of the superpowers, each of the permanent five, use their veto power to ensure there's no accountability. So we saw Russia vetoing numerous Security Council resolutions to hold Syria accountable for violating the laws of war in its efforts to quell the uprising against it. And we have a much longer record of the US government working to shield Israel from accountability at the Security Council, blocking any effort to impose even the mildest sanctions, the mildest punishments for Israeli misconduct, and including in 2021, using its veto power 3 times to block a ceasefire resolution, including in this conflict, using its veto power to block the first pause resolution that Brazil put forward and refusing to allow others to come forward, only reluctantly abstaining from the last Security Council resolution, which mildly called for a pause. So reforming the Security Council, democratizing the Security Council will, I think, increase its ability to enforce international laws. But, you know, it's not just about the laws of war where we have a dilemma, the dilemma of the commons, really, which is there are many laws and policies that we need to enforce for the good of humanity, like, for example, climate laws. And I hope people are also observing what a mockery and a sham COP28 in UAE, excuse me, has been. But that we have a nation-state system that basically allows nation-states to do whatever they want. And there's very little capacity for the international community to impose law and order for the good of humanity as a whole, because no such international body exists with the power to truly compel states around the world to comply with internationally agreed laws and rules and norms. So at some point, the nation-state system has to give way to global rules and global enforcement for the good of humanity worldwide. I don't think that nation-state leaders, governments, have gotten there yet, and I don't know if we will. So the sort of long-term prognosis for humanity in climate, not even getting to the laws of war, ain't pretty. Gotta say, not looking good. So I think this then delves into more philosophical realms of how we organize our planet, and I don't see any openness or willingness for nation states to give up their sovereignty and authority to a higher global body. But frankly, I think that's what we need.
Thank you. Sarah?
So I agree with everything there, but I just want to add that the tools are there. It's not like the tools are not there and the institutions are not there. It's all there. The issue is it actually being used? You have this hostage situation around the Security Council hijacking a lot of things. Otherwise, you have not only UN peacekeeping, as I said, you have responsibility to protect. I think what's been interesting and what's been evolving is a little bit of assertion by the General Assembly. Perhaps if we can't reform the Security Council, I hope the Security Council can be reformed. Perhaps there also has to be a consideration of strengthening inputs from the General Assembly, because they are able to issue various, you know, they have something called, I've forgotten the name. Sarah, I don't know if you remember, it's the agenda, it's the resolutions for peace. Yeah, it's the resolutions for peace, I think they're called. which basically recently also you had these resolutions, right, where countries abstained or joined on OPT and Gaza. So I think there might be a discussion around that as well, with an increasing assertion of the global South. Because however much you expand the Security Council, you might not have the representation the global South needs. What is very clear is these are the only institutions we have. We have the tools. It's a matter of getting them to work. I mean, over the years, I've always been amused when people say, "Oh, the United Nations hasn't done anything." The United Nations is composed of its member states. The UN can't do very much on its own. Having said that, yes, the Secretary General has a role called the good offices. They can use it effectively. They've used it effectively over the decades. It is a personality-driven thing. It could be used for a force of good. I think the UN just provides, well, tries to provide a moral compass, not always, but that's really the aim. So I wouldn't say the tools are not there. Just want to make another very different point, because I just got this sense. We have to remember that IHL is the minimum. It's not the maximum to rule adherence. So it's frightening when even these basic minimums of conduct and hostilities are not followed. So again, all the tools are there, because there's always been this question of IHL is, I mean, through this whole crisis, it's been like, oh, nobody respects international law. It's not that. The thing is, the tools are there. It's about sovereignty, as Sarah was saying. At the end of the day, we're all hijacked by sovereignty, by how the institutions are getting run. So perhaps there has to be a discussion beyond that. And I think this empowerment of the global South might help as well. Yeah, thanks.
Thank you, Sarah. We don't have much time, I think like 4 or 5 minutes. So what I will just do is read out a couple of the other comments, so you'll have a sense of what people are saying. And I'll leave it to you to respond in a short while, as shortly as possible to the comments being raised. Clifton, I'll give you the final word as well on the point once I read out the question. When Israel says they are defending themselves, but the question is from whom they're defending. Palestinians don't have military, no arms, no resources. Gaza is an open-air prison, and Israel is fully equipped with arms military. Who are they defending from? The second, the human rights activist question I read. Okay. The other question is, this week, the whole of the US Congress, except 2 lawmakers, voted, among other things, in favor of equating criticism of anti-Zionism to anti-Semitism. Is there any hope from the so-called progressive politicians in the US? Can one or both of you speak about land capture in international law? How is this understood in terms of this conflict? One more point, I'll just read this out. Why do you think there's a dichotomy between the stated ideals of universal human rights and international laws about war crimes vis-a-vis the practice by the powerful global north? Yeah, these are the questions. Clifton, you have any thoughts? You can please comment on that, and then we can give both Sarahs a quick 1 minute to comment.
No, I mean, I think you kind of covered most. I just thought it was really a very necessary conversation in that sense. On the one hand, the kind of an approach, which kind of discards the entire framework of international humanitarian law, saying that, see, it's really not working and there's really no point in it. I think from that to also the point that which Sarah Khan was also making, in terms of for us to move beyond it and saying that how do you actually end these kinds of conflicts. So I think the conversation has really ranged, it's gone from, the pendulum has swung both ways on this. So it's really been interesting. And I think it's amazing that, so many people stayed on in this till now. Because I think that's how important it is for people, to ensure that there is justice in Palestine. But yeah, I mean, just thank you to both of you. Just incredible in terms of the scope of this, the scan of this.
Yeah. Thank you again. Thank you to both of you, and really thank you for making time to come for this particular event. As you can see, that many people have stayed for a very long time, as Clifton has already indicated, and we're both I think we feel very educated by this entire discussion, and the complexity and the range of thoughts thrown up, and by bringing that level of thinking around the entire issue. And we'll take this conversation forward. And Sarali, if you're ever in India, any part of the country, we'll be happy to host you. So please do let us know.
Yes, I will be in Delhi next week. I'm very excited. But thank you for having me, and thanks for organizing this.
Thanks. Just to let you know, we beat the trolls. They have just started coming in now in hordes.
Bring them on. I'm ready. Make some more fun.
Yeah, thank you. Thank you, Sarah.
Thank you.
Thank you, Sarah.
Bye.
And thanks everyone for being patient and staying through this entire conversation. Thank you.